Hey, everybody, and welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel. We're here pretty much each and every Thursday night. We missed last week for Thanksgiving. Hope everybody got a little bit of time off, hopefully to relax, be with family, and not think about the kind of issues that we're going to talk about today, which are debt issues that can be overwhelming, stressful, and cause a lot of grief. So the whole point of what I do on the Consumer Warrior YouTube channel is to provide some tips and strategies on how to deal with pretty serious debt problems, whether you're looking at like a bankruptcy type situation or, wage garnishment, debt collection lawsuits, that kind of stuff. I am a licensed attorney in the state of Arizona. My information's here scrolling across the bottom. If you need legal help and you're in Arizona, feel free to give me a call. I do free consultations for debt collection lawsuits and for bankruptcy filings. So the way that we do this each and every week is if you have a question, if you're on Facebook or if you're on YouTube, go ahead and put it in the chat section. I'll go ahead and put it up on the screen here and we'll talk about it. My weekly disclaimer is, like I said, I am a licensed attorney. I'm only licensed in Arizona, though. So I'm not licensed anywhere else. So you shouldn't take this to be any type of legal advice. This is some guy just talking on YouTube. So take that for what it's worth. But I'll try to give you some resources and some things that can help you kind of do a deeper dive. A couple of resources we have that are down in the notes underneath are Consumer Warrior University, which is what I put together. These are some deep dive courses, templates, forms that'll help you if you're dealing with a debt collection lawsuit, as well as one of the sponsors of our weekly live stream, SoloSuit. SoloSuit is a cool company that uses technology to help people do things like drafting answers to lawsuits, debt settlement, debt validation letters. A lot of cool stuff there. Go ahead and check them out. So I was looking through the comments over at the channel this morning, and a couple of things that I thought would be good to go over that might be applicable to everyone. This first question said, I have a trial coming up in January. Can I file a motion to dismiss, get up over there, before this date? They did not send me any discovery or admission. Is it too late to file a motion to dismiss? The answer is probably. So a motion to dismiss the case and a motion for summary judgment. Both of those types of motions, they dispose of the case completely. They're called dispositive motions because they basically they take away your right to go to trial if they're granted. So usually in most courts, there is a dispositive motion deadline. It's usually about 90 days before trial date. And if you don't file a motion, your dispositive motion, whether that's motion for summary judgment or motion to dismiss, before that dispositive deadline, then you're barred from filing it. So my guess is that you're probably outside that window because you're so close. The rules may be different in your court. You could check that out. Also, a motion to dismiss is usually only used if there's something defective in the actual pleading, the complaint. So they file their lawsuit, they file the complaint, the summons, you receive that. If there's something that's defective in there, as far as whether it's statute of limitations or whether it's venue or the jurisdiction, whatever, that's usually when a motion to dismiss is filed. If it's something you feel like they haven't proven their case and they can't prove their case, then you'd probably look at a motion for summary judgment. So that's probably what I do. I check first to see, though, if you're within the time frame to be able to file it. This next question said, what could happen if after filing a Chapter 13 bankruptcy, I sell my home and have some equity on it? So good question. So Chapter 13 bankruptcy is where you pay back a portion of your debt over time. Usually it's a 3 to 5 year period, usually 5 years. Once you've completed your bankruptcy, and this is true with a Chapter 7. Chapter 7 is about a 4 to 5 month process. When the case is discharged and then closed. So there's two steps. The discharge order is that order from your judge that says that you don't owe these debts anymore. And then the court or the clerk of the court will administratively close your case. Once it's closed out, you can do what you want. The case is over. You can sell the property. But if you try to sell the property while you're in a Chapter 13 or before it's closed out or before it's discharged, you're going to have to get permission from the trustee and from the court. And this question is one that we run into quite a bit. It says, what does business credit get discharged? So if you own your own business and you have, let's say you have a business credit card or a business line of credit or something like that, sometimes if a small business fails, people are like, okay, I need to file for bankruptcy. Now, it's important to know if you have like an LLC or corporation that you're running your business out of, and the debts belong to the business. The thing that gets discharged in your bankruptcy is your personal liability. Usually there's a personal guarantee, something like that connected to those cards. That personal liability that you have is discharged through the bankruptcy. Now, what the kind of the fine line here of things is that the creditor can actually continue to contact the business entity. And if it's an LLC and you're the only member of it, there's this kind of weird thing where it's like you're wearing your business hat and then your personal hat. They can send it to you when you're wearing your business hat, but not your personal hat. So business debts, and this kind of goes along, I've talked about before in chapter 7. Typically, chapter 7 is not for businesses. There's really not usually a big reason to file it for a business because a business does not get a discharge. And the discharge is the order you get from the court that states that your debts are no longer owed. And so that's kind of, how that plays out. So your personal liability on that will go away, but likely nothing else. So, okay, let's go ahead and jump into some of the questions. Sal was here nice and early with a 4-part question. So let's go through it. Hi, John. Tomorrow's court day. D-Day. It's time to do it. It says you'll probably remember me. I filed a motion to vacate a default judgment that was entered back in 2019, and there is no certificate of service on file. I have received some documents from the substitute attorney who I think it'll be in the court tomorrow instead of the original attorney. Won't that be classified as the hearsay rule? I don't know if it's also the witness. What can I expect for tomorrow? What can I do? I can also find out the account number, find out if the card account number is correct. Okay, so as far as what to expect, typically this is kind of funny because when I was a brand new attorney, I remember the first time I go to a courtroom, you've been preparing, you got the law, you got the paperwork, you got the briefcase, you're all ready to go. And I walked in, it's like, which side of the room do I sit on? Because there's 2 desks there in front of the court. And a lot of courts nowadays, it'll say plaintiff and defendant. So you know which one to sit on. But in most jurisdictions, if there's a jury box where like the jury would sit, usually the plaintiff will sit closest to the jury and the defendant will sit furthest away from the jury. So that's just a little pro tip there to help you out and kind of alleviate some of those concerns. Another pro tip I have is I would get there early. I also learned this early on in my career. Attorneys, we have a lot of stuff. We try to pack a lot of different things in all day long. And so I'd be running in from one hearing to the other, getting back, drafting something up. And I was showing up, on time, but, kind of flustered or, something happened with the parking. Or get there early. Get there a half an hour early. Go and sit in the back of the courtroom. Maybe watch how the judge does things, see how the demeanor of the judge, that kind of stuff. So that's what I would recommend. And then as far as the motion, how that goes. So you filed a motion to vacate. I'm assuming it sounds like they filed a response. It sounds like the court has set this for oral argument. So this isn't a trial. At least it doesn't sound like an evidentiary hearing where evidence is actually taken. The judge will have you go first because you filed the motion and have you explain or argue your position as far as why the judgment should be set aside. Once you're done, then the plaintiff, they'll have an opportunity to respond to that. And then as the movant, as the party who filed the motion, you get the last word. And then the court will either issue a ruling right then and there, or what they do a lot of times is they will take it under advisement and they'll issue a written ruling later on. So that would be what to expect. As far as, your motion to vacate, if there's no certificate of service, that's going to be your argument, it sounds like. They've got to prove that they served you in an appropriate manner for the court to even have jurisdiction over the case. And so if they didn't do that, if they don't have a certificate of service, that means that there's no proof that you were ever served, and the court should set that aside. So good luck with that. I know that can be really stressful, but good luck with that. All right, Al, thank you for supporting the channel like you do each and every week. It says if a vehicle in 2 names is repossessed and the finance company auctions it off for less and sues for the balance, are both owners sued individually and each garnished? They are not married. This is a good question. So if the vehicle is, like sometimes there's a cosigner, or sometimes people just buy it jointly. In Arizona, we see titles that will say, and or, so John and or, whatever, whoever the other person who bought it was. So if they auction it off, and they don't get the full balance. So if there's some money left over that's owed, that's called the deficiency balance. Then yes, then they can sue both parties. Usually what those contracts say is that there's joint and several liability. That means that you're both 50-50 and you owe the whole thing. So they can go after either of you, either for a portion of it or for the full amount. And so, I mean, they can't collect more than the total amount that's still owed, but they can go after either of you for it until that balance does get paid. All right, Shaka, thank you for supporting the channel. Appreciate it. Mailed off grounds of my defense today. Should I request the purchase agreement? Should I subpoena the signer of the affidavit? I'm ready. Thanks to you. Awesome. And you know what? That's what alleviates a lot of the concern. When I'm not prepared, that's when I'm stressed out. If I'm prepared, if I put in the time to do that, then it's just a matter of going and presenting it. And even when I'm going into court, it's something when I go to court, even now, sometimes I'll practice out loud what it is I'm going to say because I like to run through it, hear how it's going to flow, that kind of thing. So, as far as whether you should request the purchase agreement, couple thoughts on that. I always say, in the Consumer Warrior University, I have a course on discovery. And I understand the thinking and the urge to say, you know what, I'm going to make this junk debt buyer prove that my account was in there, and I'm going to request all these documents because they haven't provided me anything. I kind of think of it the other way. If I get a case from a client and there is no documentation that the other side has provided me, I'm good. And the reason why I'm good is because the plaintiff, they bear the burden of proof in law. So when they go to trial, you don't have to disprove anything. They've got to prove that you had the account, what the terms were, that you breached it. And then if they're a debt buyer, they have to show that it was transferred or your specific account was assigned. And if they don't have evidence to do that, then they're going to be in a position where they can't meet their burden of proof and they're going to lose their case. So sometimes I know that, I've read some other attorneys will often request the purchase agreement because the courts will often, require them to turn it over. So there's something called a forward flow agreement or the purchase agreement. They don't want this out in the public. It's got what they consider business, secrets in there. It's got confidential information as far as what they paid for the debt. And they don't want their competition seeing that. So I have seen in the past when a court's ordered them, go ahead and turn it over, they'll just dismiss rather than turn it over. It's kind of they'll lose the battle, but win the war kind of thing. So I've seen people do that. Sometimes there is a need to do it, particularly if they, like I said, usually if they don't have anything, then I don't request it. Sometimes I've seen them, in rare cases when they do provide it, it's so heavily redacted that basically you can't read it. I'll ask for an unredacted copy. But I usually don't request the purchase agreement. The signer of the affidavit, you could do that. I can tell you this. So I'm getting ready for a trial right now. On the other side, I have a trial next Wednesday against a junk debt buyer. And they have in the proposed exhibits, the other attorney submitted an affidavit from the original creditor. Now, I'm going to object all over when it comes to that, because when you get to trial, in most jurisdictions, an affidavit is not allowed. It's hearsay. It's an out-of-court statement. It's written, and the reason why is because you can't cross-examine an affidavit. If they come in and say, Judge, here's this affidavit, there it is. Take a look at it. Then, if it's a witness and they come up there and they testify, then I, as the attorney for the defendant, I can get up and I can cross-examine them, ask questions, kind of see where the strengths and weaknesses of their testimony. Whereas if it's just an affidavit, you can't. It's hearsay. It's Rule 802 in most jurisdictions under the rules of evidence, and you can object for that being hearsay. So, all right. Okay, Sal had to follow. It kind of goes along. It says, will the hearsay rule apply if the collection company replaced the original attorney to be in court? No, I mean, so your situation is a little bit different, Sal, as far as a motion. If you're arguing a motion, hearsay is not going to really come into it. I guess the only way it would come into it is if the other attorney stood up and said, the process server said this, or, we don't have their affidavit, but they said this. If they're trying to say, what did the process server say without the process server being there? So, but the other attorney will be able to argue it, regardless. So, all right, let's see here. Carla says, received a letter from a lawyer offering to help with my lawsuit. That's how I found out. Portfolios filed against me on November 3rd. I haven't been served with papers yet. Advice on what I do once served. So a lot of people will find out about that, by the way. There are companies, I've used them myself, that they go to the court's docket, and anytime a new lawsuit's filed, they can purchase that information and then do a direct mailing campaign. That's how they find out. But like here in Arizona, when the creditor actually files their complaint with the court, they have 90 days to serve you. So it's possible, they filed on November 3rd, and here we are, November 30th, a month later, and they haven't served you yet. Well, they probably have 60 days more to serve you, at least if it's in Arizona. So once you do get served, my recommendation, first of all, is not to avoid service. I know this is controversial in the internet. But a lot of people say, just avoid them and then you'll win, kind of thing. Usually what happens is if they can't serve you, if they can't, services when they come by and they knock on the door and they literally put it in your hand, kind of thing. If they can't serve you, then it's a situation where often they'll go back to the court and sometimes get permission to do what's called alternative service or some type of substitute service, where instead of coming by your house, the court allows them just to mail it to you. I've even seen them allowed to email it to you or come and tape a copy to your door. The problem is a lot of times you don't see that. I've had clients where they said they taped it to their door. There's a storm, it blows it into the bushes, and they're not even aware of it. And then they end up with a default judgment. To me, it's better just to deal with it head on. There are defenses. We talk about them all day here on my channel. That's what we talk about. There are defenses and ways to deal with it, because once a default is entered, then you're kind of stuck. There's not a lot of great arguments there. So that's what I'd recommend. Check out in the link, the Consumer Warrior University, a solo suit. They'll have templates to help you to respond to it. If you're in Arizona, you can give my office a call. We can do a consultation and help you out there. So, all right. This one said, I won my motion to compel arbitration. Nice job. But then the plaintiff filed a motion for the defendant to initiate arbitration with AAA within 90 days, and the judge signed it. I thought the plaintiff initiated it. This is the age-old question: who's going to initiate arbitration? So I can tell you this: when I first started filing motions to compel arbitration, I took that position. I took the position that, look, it would be ridiculous for me to file the arbitration. I don't have a claim against, portfolio recovery. I don't have a claim against Capital One. They sued me. They sued my client. Why should I file the arbitration against them? However, the creditors often will not initiate it. And then what they do is they come back to the judge and they say, hey, judge, you said, they filed a motion to compel arbitration and they didn't do anything. And I found too often, at least here in Arizona, that the judges were like, yeah, you should have gone and initiated it. Arbitration is also a little bit different. I can tell you, like a AAA, when I initiated an arbitration, it's a fairly straightforward process. And really what all they're doing is they're getting the parties and then assigning an arbitrator so that there can be a hearing, regardless of who has the claims. Essentially, you're filing a petition stating what your defenses are to that claim. You're just moving it from one venue to the other. So I would say go ahead and do it. Go ahead. You'll see with AAA, there is a filing fee. I believe it's like $200 for consumers. It's much more expensive. It's about 10 times that for businesses. So, but if the court has granted it, I think, to show good faith, you've got to proceed with it. You need to be, I always say, if you're going to file a motion to compel private arbitration, you need to be ready to go forward with it in the event that they follow you in there and move forward with it. So, that's what I'd recommend, is go ahead and initiate it. Go to AAA, take a look at it. I have a video, it's in the Consumer Warrior University. I did a little video showing how that's all set up. But that would be my recommendation. So, all right, Shaka, thank you again. Man, that's double today. Thank you. Can I pay you to do a mock trial? I'm not asking for legal advice. I just want to run a defense by an experienced source. I wish I could. I would love to do that kind of stuff all day long. Again, I'm only licensed here in Arizona, so I got to be careful as far as that kind of stuff. We have a lot of people who try to set up consultations with me here in my law practice in Arizona, and I can't even do the consultations because once it gets one-on-one, that becomes a bigger issue. So check out if you're not a member of the Consumer Warrior University, sign up for there. I have an entire tutorial that's called Preparing for Trial from beginning to end, and it walks you through that. That would be a great course for you to take a look at, because that's something where we go over all the stuff you have to do when you actually get into court, kind of the nuts and bolts of what to expect there. So, all right, everybody. Well, hey, thanks for checking in tonight. I am getting in the process. I have a whole, I'm using the new ChatGPT account to create a whole series of videos that we're getting ready to put together. I've been really slacking the last few months. There's no getting around it. I haven't put out as many videos as I used to. And so I've got a lot. This transition into my own practice again has been something that's been pretty significant and time consuming, but I'm ready to get a bunch of other videos. All right, you know what? There's a couple more. Let's jump in those. So Edgar says, I did file Chapter 13. My court hearing is December 13th. Once my payment is settled, am I not allowed to buy anything after that? So with a Chapter 13, I can tell you this. So the idea behind a Chapter 13 is that you're going to devote all of your disposable income to your creditors for a certain period of time, usually 3 to 5 years. And then at the end of that 3 to 5 year period, any balances that are left over are going to be eliminated at that point. So, so your court hearing, my guess is it's a confirmation hearing. So once your plan is confirmed, the plan that you propose to your creditors, once it's confirmed, it's not that you can't buy anything. Now, you can't get into more debt or incur new debt without permission from the court. But you know, with Chapter 13, I mean, it's not like someone's looking at your bank statements every week. There is a budget built into your plan. If you're in a 13, you usually have an attorney. I always say, talk to your attorney if there's anything substantial you need to buy. But as long as you're making your plan payments and the plan's been confirmed and everybody's on board, you can kind of just live your life and work through it. Dark Emperor says, I have funds in an investment account that I want to transfer to a Roth solo 401k so that the funds are protected in a personal bankruptcy. How long after the transfer should I wait before filing? So this is a very state-specific question. In Arizona, it's kind of interesting because the state statute, the Arizona state statute that says that 401ks are exempt, states that any contributions within 120 days prior to filing bankruptcy are not exempt. However, the federal court, the federal rules, the exemption says it's exempt regardless. And so due to the supremacy clause here, the federal statute trumps the state statute. And in Arizona, there's not really a waiting period. I do tell people if they transfer it, it's probably not in your best interest to file the next day. You're just asking for unwanted scrutiny. I'd probably wait a couple months and then file the case. But for sure, talk to an attorney on that. You need to find out anytime that there's any kind of what we call exemption planning, you need to make sure you're getting sound advice on that. So, all right. I think that will do it for this Thursday night. Thank you, everybody, for checking in. Again, check out our sponsor here, Solo Suit, and all that they can do, as well as the Consumer Warrior University. With that, we'll catch you next week.